Can I just say something about Andrea?
Good morning, guys. We made it. Friday, end of the week, last day of the preliminary hearing. State's rested. Smooth sailing from here. One more defense witness to go through. Another ATF expert. Any reason to expect it won't be more of the same? Just what we've already seen. Raising questions about some of the uncertainties around the edges, which is really kind of characteristic of good science anyway. Good science is, by its nature, uncertain. It's mostly the bad science that's going to tell you it's absolutely 100% confident. Totally true. Absolutely. Not really how science works in the modern day, in the post-Karl Popper era, where we look at falsifiability and probabilities and things like that. So, expecting nothing too surprising, but of course we'll see. We'll see. Never know. I was hoping that when we got started this morning, we were going to have some new briefs to talk about. Yesterday, Judge Graff told us, he'd received the filings from the state, from the defense. I was really curious to read through the state's argument. This is all relating to the editing the Lance interview and not showing us certain exhibits and all that stuff because it's too incriminating. It has confessions that aren't, that the defense wants to be treated as confessions but insists aren't. I was really curious to read some of this reasoning, because obviously the argument in court seemed to be tracking pretty close to what I thought and what we talked about on the stream the night before. But they're not up yet. Not up yet. I did go check. Still haven't hit the docket. Not super uncommon when they're stuck in a long hearing like this. They went long yesterday, past their normal close of business. They've been going all day. Not really that surprising that it can take them a while to catch up on filings and things that happened during the middle of the week. But we don't have it, unfortunately, so we don't get to take a look at it right now. I'll continue to keep an eye on it, see if it pops up, and maybe we'll have it for our recap tonight. Guys, I'm going to keep the recap at 7:30 p.m. Pacific time. Largely for consistency's sake, and also just because we don't actually know how long it's going to take today. They have grand aspirations that it's going to be pretty quick. That's what we were told. It won't take very long. Yeah, not very long by lawyer standards. It could still easily mean by lunchtime, after lunchtime. We just don't know. So, it's just so we're not worried, no issue or anything like that. I'm just going to go ahead and keep it at 7:30. And what we're going to do is we're going to sit down with the information. We're going to look at the actual charges and compare that to what we've seen. Talk about where we are. Anything to be concerned about, any issues, anything that might fall off. Just try to get a sense of where we can anticipate the ruling going. So for now, as we enter the conclusion of this part of the process, I think the helpful thing to do, because it has been a long week, put in a lot of hours, seen a lot, pause and just kind of recap our takeaways, our big picture, important things. What have we seen? over the course of this week. Take ourselves all the way back to Monday when this was just getting started. And we were first hearing from UVU police officer Christopher Bagley. Remember him? I barely remember what he looks like at this point. Christopher Bagley was our only percipient witness to the shooting. He's the only one that was there at the scene, able to describe what he saw, what he experienced. Heard a gunshot. Heard a gunshot. It's amazing to me that there should be any controversy in this. Really is kind of amazing that there would be any controversy about that, because of course, within seconds of Charlie being shot, hundreds, if not thousands of people present at UVU were on social media tweeting out, holy shit, Charlie got shot, texting their friends, Charlie got shot. Like, everybody knew Charlie got shot. Then the video's out. We're all seeing it whether we like it or not, if we are online on September the 10th. And we're all seeing and hearing Charlie get shot. Amazing that that should be controversial, but just speaks to the power of mind control, thought control, manipulation, gaslighting. Something that is really obvious to millions of people the moment it happens. If you can like call that into question, deny that, then you got some significant power over people's minds. Heard a gunshot, Mr. Bagley did. We knew it was a rifle and not a handgun because of that snap, crackle, pop, the bang pop. Bang versus a crack. Bang versus a crack. One of those issues that hard for me to like give that a ton of weight, right? Oh, a cop has ears, special ears, can distinguish between sounds, kind of thing. In a vacuum, like if we didn't all have this on video, hadn't all seen it for ourselves and stuff like that, probably real inclined to, you know, I'll take it, but I'm going to be skeptical. Going to be skeptical that the ears distinguish, but at the same time, I do kind of know what he means. Really do. Go to the range, drive up. You can't see anything, but you can tell right away. Rifle range is over there. Pistols are over there. There is something different about the sound. We had some really interesting conversations about that, and why that might be. Supersonic versus subsonic, but that's probably not it, because the handgun is also generally going to be supersonic. But there is a difference. So the bang versus the crack. He heard a crack, made him think it was a rifle. He didn't realize that right away, though, because they found the abandoned holster at the top of the amphitheater. Handgun, like a concealed pistol holster. And it was only when he saw that it had registered, wait a minute, what I heard was a rifle. And that's what made him think, better check out the roof of the Losee Center, because he realizes there's a line of sight. It's a rifle. So he goes there to check it out. Finds a screwdriver on the roof. Finds the impressions that he describes as the sniper pad. He describes it as showing impressions from the elbows, knees, and feet. We haven't seen it. He said the day photos weren't very good, but the night photos were better, which I would expect. It's going to be more contrast with the lighting at the same time. That can be distorting, you know. So we haven't seen it yet, but definitely interested to see that. And then lastly, at the northeast corner of the building on the ground, he finds the shoe impression on the grass, sees that, and so then he looks up and he sees scuff on the northeast corner of the building. He describes as the scuff. We also heard from Agent Hull, started hearing from Agent Hull. And from that, we heard there was at least one more bullet found at the scene. This is where we heard about the holster that was found. Learned that there was an autopsy. Not surprising. Dr. Guajardo performed the autopsy. We learned about the surveillance footage, and that it showed Tyler Robinson, who they are alleging to be Tyler Robinson, who they are alleging to be the same individual throughout the course of the day, on campus 4 times on September the 10th. Three times before and in the act of, the time of the shooting, and then later again that night. We learned that Tyler Robinson had an interaction with the police the night of September the 10th. And we learned that very obliquely, and not in a lot of detail, but that cell phone data helped them place Tyler in that location. This is a foreshadowing of a extremely valuable and probative source of information when it's available: cell phone location data. It's data you can get from your phone, GPS, stuff like that. It's phone you can get from cloud servers, your iCloud backup, and stuff like that, through different apps that track it, that data would get uploaded. So things like your searches, your Google Maps directions, stuff like that. Activity can be tracked and stored on the cloud. And then, less valuable than the GPS, but still commonly used for investigation, the cell site location data that they get from the cell tower that tells them which phone is pinging off of this tower. And they can go in and trace that. Preview. Just a very oblique little reference to cell data, putting him, being able to help them track his location, put him in a specific area. That is likely only going to get more substantial, because it's going to benefit one side or the other. It will help the state put him there. It will help the defense show he's not. So almost certainly going to hear more about that as we get to trial. Moving on into day 2, we learned more about this bullet that was recovered at the scene, this other bullet. We learned that they accounted for it as having been cycled through one of the guns of one of the police officers on the scene. So they ruled it out as having any role to play in this shooting of Charlie Kirk. Some question about other guns at the scene. Not quite sure if it's been substantiated beyond there was another gun in the backpack, a backpack that was found at the scene. But the lost holster that we heard about, seems to be some conflict about whether it had a gun in it or not. We don't know yet how that's resolved. First, heard on day 2 about Tyler voluntarily surrendering to law enforcement, driven by his parents to turn himself in. And it was the defense who brought that up repeatedly, highlighted it, emphasized it. Tyler voluntarily surrendered. So we know the defense is leaning into that. They're not fighting that. They're not disputing it, not arguing it. We got to see finally the video of the surveillance footage. What we've seen so far was mostly the screenshots from it, with the exception of that one short bit from the roof that has the zooming and the highlighting, so that you can see more clearly. See the person come off the corner of the roof and start running towards the parking lot. So that part wasn't new, but I found it very helpful to see what they were describing as in the probable cause information as the gait, the awkward gait, the stiff gait. Kind of looks like somebody's got something shoved down his pants. To see that for ourselves, because the screenshots, of course, don't really make that clear what they mean. So we got to see it for ourselves, and now I get it. Now I get what they mean. Yeah, like a stiff leg that's being dragged, going up the stairs, one step, you know, not the normal. For me anyway, I'm a like take 2 steps at the time kind of person, but I'm tall. So seeing that I thought was very very helpful. And then also the video from the earlier in the day that just is, yeah, the parking garage in particular. This is some very high quality video. You can see pretty clearly. On day 2, we also learned that the DNA on the towel and on the screwdriver were a match. Asserted to be a match to Lance and Tyler. Day 3 was our short day, Wednesday. It was aggravating because we got lots of argument, but we did still get some good quality information. We got the timeline now of the surrender and arrest, taking of Tyler into custody. 9:00 p.m. when he surrendered to Washington County Sheriff's Office. We learned a little bit more about the second bullet, the one that defense brought it up. David Holes, like, we accounted for it. It was cycled through the gun of one of the cops at the scene. Explained how that worked, by the way, too, because the rifle they keep in the cruiser ready condition, meaning no round chambered. When it's in the cruiser, no rounds. So then when you deploy and you take your gun, you have to chamber a round. But then when you put it back in the gun, you have to remove the round from the chamber. So can happen. You eject it. That's how they would know it was cycled. It would have the ejector marks on the casing of that cartridge. But dropped it. And that's going to create a lot of paperwork for that police officer. Nevertheless, they were able to account for it. Anyway, more detail about why it wasn't particularly probative in the opinion of the investigators, because the location of where it was found gave no line of sight to the tent where Charlie was shot, and it was .223, relatively small caliber, certainly small caliber for a long gun, and not consistent with what we are later to learn are the bullet fragments that were recovered during Charlie's autopsy. So that's most of what we got out of day 3. And then yesterday was the tying all the pieces together. See the person on the video, the morning video. Yeah, I think it's not rocket science to look at that, and looks a lot like Tyler. The ones during the time of the shooting, granted, not quite as clear. Not quite as clear. But otherwise, the only direct link we have is we have a screwdriver We have him associated with the screwdriver and the towel. It's not nothing, but it's not really the strongest case for connection because, you know, you can donate household items to Goodwill. Other people can have them and use them. It's not on the gun itself at this point. And we have the surrender, which is certainly a thing, definitely a thing you would consider. But any high-profile incident is going to attract kooks. It's going to attract kooks. So, haven't quite ruled out yet. This could just be some kook that surrendered himself. Possible. But yesterday was really about strengthening those connections between Tyler and the gun, Tyler and the crime. And that started with Lance's statement that we got to watch, Lance's interview. And that was further corroborated by the text messages that we got to see, the statements that were made in this text chain. Significant to me, the text that indicates he left the gun wrapped in the towel in the bush. That is an extremely accurate description of how police found the gun. So that is some incriminating knowledge for him to be communicating. The statement from Lance that when he saw Tyler the last time, and Tyler began to cry and say he wished he hadn't done it. Pretty incriminating, pretty self-incriminating thing to say. Wishing you hadn't done it is really saying that you did. You wouldn't wish you hadn't done it if you hadn't, in fact, done it. You wouldn't have to because you wouldn't have done it. It's only because you did it that you would wish you hadn't done it. So very incriminating, but also from the defense standpoint, again, this is potentially helpful, at least from the mitigation side, for purposes of an argument that this person is capable of remorse. This person is capable of rehabilitation. This is not somebody who is irreparably depraved. And so this isn't the kind of person who is the worst of the worst for whom we normally reserve the death penalty. We got a lot of details about DNA results from the variety of different objects, the cartridges that were found, the casings that were found, the gun itself, the Dremel tool. Lots of mixtures. Lots of mixtures. Tyler is the major contributor in the analysis to all of these mixtures, but the fact of them being mixtures is previewing that there are going to be technical challenges that the defense will raise. They'll argue it's not as easy as just interpreting a single source DNA profile. There's a lot more uncertainty surrounding that. So we already know that's coming. The defense has told us before, and Mr. McBride also, making sure we understand there are going to be multi-day hearings about the validity of the science. We're going to hear from the studies. We're going to hear from the experts. So that will be coming. I, for one, I can't wait. I really can't. The only thing that will make me happier is if they're doing next gen DNA analysis in the background, you know, where we can't see it because it's the investigative stuff. And we get to talk about that too. We get to learn about the emerging technologies because they're both exciting and scary. Really exciting, really scary. They open up so many doors and so many possibilities in terms of being able to develop evidence more precisely, which we all want. We don't want false positives. We don't want somebody being incorrectly identified by something. So the more precise we can be, the more helpful that's going to be. But we are going down a very slippery slope of the volume of personal, private, medical, biographical information that is available now to people with the tools to pick up a few skin cells and develop your entire genetic code. And this is in a context, in a legal context, where your ability to kind of maintain control over your genetic privacy is real limited. Because we don't control our shedding. We're getting into kind of this Gattaca. You guys remember Gattaca? Wasn't like the best movie ever. It's old. I don't even remember when it came out now. But it was what's his name that used to be married to Uma Thurman? Ethan Hawke. Ethan Hawke was in it. Anyway, it's like this dystopic movie of where, like, I don't know, genetic purity is a thing, and this guy, the Ethan Hawke character, he's not actually genetically pure, but he's like trying to pass, and so he has to like super scrub himself, make sure he has like no loose hair and things like that, because yeah, that's the kind of thing everybody sheds throughout the day. And our legal structure as it exists right now, we just treat that as that's abandoned. You go out into the world, you leave DNA, you've abandoned it. So you no longer have any expectation of privacy. So anybody who can get a hold of it can do what they want. And if you don't have an expectation of privacy in it, then it can be captured, compiled, databased. This is potentially alarming stuff over the horizon. So that's like the only thing that would make me more excited than just knowing we're going to be having more DNA to talk about. And then we also got the tool marks. We got the voodoo, the tool mark voodoo. I remain baffled about why we did a lot of exploring of the tool mark voodoo with respect to the conclusion that the ATF analyst made that was actually mostly beneficial to the defense. It's inconclusive. She can't say this came from the gun. She can't say it didn't, but she can't say it did. It's helpful to the defense. The one that wasn't helpful to the defense was her claim, I can say definitively that the Dremel tool that was found in Tyler Robinson's closet made the engravings on these different cartridges. The one found at his house, test fire. The one that was fired inside the cartridge casing that was fired and was found inside the chamber of the rifle. And then the unfired cartridges that were inside the rifle. Dremel tool made all those. That seems to me where the logical point was to focus this criticism of the tool marks, because that's the damaging piece of evidence that you're trying to undermine. But for some reason, the defense didn't focus on that at all. Didn't focus on the Dremel tool at all. They focused on the jacket casing and just found that a little bit strange. Don't disagree with them in you know, the 10,000 foot view that this is largely voodoo. Granted that we can all put things under a microscope, magnify it, blow it way up, look at it with our eyeballs. It doesn't take magic eyeballs to see, do these things look similar? The whole problem and the limitation of this this method is, what does similarity mean? How similar is significant? How dissimilar is significant? Because we know there is variability in the marks that a single gun will put on successive bullets, and there are variations, between firearms as well. They can be very, very similar marks coming from different guns, very different marks, and we don't really know enough about how similar is similar enough to say these came from the same gun. We don't know if that's even possible. Frankly, we don't know. We don't know. There hasn't been enough foundational validity established to do that. And so because of that, we don't have the tools to be able to set standards for things like, even with something like fingerprints, it's still very similar. They call these feature comparison forensic methods. Many of them have been criticized for quite a long time. Fingerprints is a feature comparison method. You're looking at two different things, you're looking at their features, and you're comparing them to see if they're the same or not the same. At least with fingerprints, they have a standard. You got to find 7, you got to find 10, you got to find 14 points of comparison. Oh, looks like court's getting ready to go. Oops. Let's see what we got here.
Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill for the state, and the County Attorney Jeff Gray and Chris Ballard are also here.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser, and Michael Burke here for Mr. Robinson, who's seated in the courtroom.
Good morning.
Good morning.
Mr. Robinson, good morning to you. And for the record, the court also recognizes the presence of victim representative Ms. Erica Kirk. Ms. Kirk, good morning to you as well. First, with respect to courtroom protocol to maintain security and decorum, any individual that exits the courtroom during proceedings will not be permitted to re-enter until recess. After recess, all counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern.
You guys. Why? Do you want to be done today or not?
The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court-to-court order.
And I apologize, would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with
We had that little inadvertent
Have you
slip
both
yesterday,
reviewed the court's standing decorum order?
but not sure it was really the camera
Do you
guy's
understand the
fault.
requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order?
No.
All right, thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
Oh, of course they do.
Mr. Novak.
Defense has an issue.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions that you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this, I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this, so I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed, and then obviously if there's a part two, then therefore to that.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just
Oh,
think
shut up.
It's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published. Before the exhibit at issue was also brought onto the screen, I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's two exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those two exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, it will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant in this case.
Thank you, sir.
That was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image, of the exhibit itself. But the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
It's not ex parte because it's
Well,
happening in open court and everybody's present.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
5-minute recess so he can go back and watch the video. Well, I'll tell you guys right now what, to me, if there's going to be a remedy for this, the proportional remedy is just put a time lag on the live stream so that you can catch little inadvertent things like this and take it out before the live stream goes live. That's it. That's all you need to do. That's not uncommon at all in trials and stuff like that. can't say 100% certain that that's what happened in Depp v. Heard, but I'm pretty sure it was. That's at least what I'm kind of remembering as I sit here. Defense, of course, is going to argue, nope, it's too risky, too many mistakes, too much at stake, and so we need to just get rid of the cameras altogether. To me, I'm going to say that's highly disproportionate, given that this was pretty clearly inadvertent. I think this was pretty clearly inadvertent. Mr. McBride, if I'm going to assign the blame, I'm assigning it to Mr. McBride because he's the one who wanted to do the juxtaposition, but didn't clarify, you know, I'm going to show this to the witness, I'm going to show this to the court, I'm going to have this on those counsel monitors, but it's not to go on the big screen, just to make sure it's real crystal clear to everybody what he's doing and what they can expect, because he's handling one of the exhibits that wasn't supposed to be seen on TV. He didn't do that. They put it up on the big screen. Camera's already on the big screen. So it happened. And he's right. Yeah, it's out there now. Of course, it's out there. But the media lawyer also has a really good point. We already know what it says. This is all about the note that was under the keyboard, according to Lance's testimony. Found the note under Tyler Robinson's keyboard after he got that 11 p.m. auto text from Tyler. Said, drop everything, go look under my keyboard. Finds this note. We already knew what the note said. I'm so glad the media lawyer finally brought up the search warrants, screaming that yesterday. A variety of these things, the texts in particular. We already know what they say. More of them came out in the search warrants also. And thank you, by the way, as an aside, to the many of you who have filled my inbox with the search warrants you have collected. I appreciate that so much. I will be going through and collecting those and maybe compiling them in a separate format, a separate place, you know, like on the Substack or whatever, so that we can have those available too. So yeah, the only thing we saw about this note that we didn't previously know is what condition it was in when Lance took the photo of it. And so that's the juxtaposition. That's the juxtaposition. And so I guess that's the prejudice. You know, it's implies that Tyler is the one who burned the note, consciousness of guilt, obstructing, you know, destroying evidence, that kind of thing, which is such a relatively minor piece in all of this, but nevertheless, yeah, okay. But that's what we're here for this hearing to do, is establish the state's case for why they are saying they believe Tyler Robinson committed the crime. I mean, it's certainly not more incriminating that he burned the note than it is that he said, I wish I hadn't done it, and then surrendered himself to the police and told his friends on Discord he did it. So and that was why I was like really upset that we weren't getting to see this note. Like, we already know what it says. All I want to see is the condition, because that's the question. Did Lance burn it? Did Tyler burn it? And so according to how it unfolded, Lance took the photo in the intact intact condition, testifies that was the last he saw it after that. So the implication is it would have been Tyler. Would have been Tyler who burned it. It's really all I want to know. And it's less because it's such an important fact vis-a-vis Tyler, as much as because it's an important fact vis-a-vis Lance. to what extent Lance is complicit, to what extent Lance tried to cover up for Tyler, all those types of things. If Lance is the one that burned the note, then yeah, we got a lot more of a cover-up type of situation on his part than if Tyler did. But if all Lance did was get this information and not report it, you don't have a duty to report. You can disagree with it from a moral standpoint. Should you come forward with knowledge? Should you go to police and provide what you know and all that type of thing? That's a moral issue. Legally, no obligation to report. Limited few exceptions in jurisdictions that have Good Samaritan law requirements require you to report, but very minimal, very few, usually really limited circumstances. It's like mandatory reporting kinds of circumstances. You know about child abuse, you have to report it, that kind of thing. Generally speaking, broad picture, you know about a crime, you don't have to report it. You can mind your own business. It's a moral issue. So yeah, defense is going to argue, ooh, that's a nice bunch of hair in the camera there. Defense is going to argue, as we know, oh, this is why we need to have the cameras out. State's going to be arguing, no, oh my goodness, look at that, look at that. That is actually quite a nice head of hair. Look at that, that's like Alessi-ish. I want to know who that is. Whose hair is that? Doesn't have the thinness in the back. Wow, let's just take it all in. A glorious mane. Anyway, we know that the state is going to argue, hey, mistakes happen. It's inevitable. Defendant's entitled to a fair trial, not a perfect one. So while this shouldn't have happened, the focus really needs to be on how big of a deal was it, and what can we learn from it to make sure we minimize harm from these types of things, try to keep that from happening again, but also don't overshoot, overcompensate in a way that is damaging to the process because it's keeping more of it away from the public eye. And so to me, the answer seems really straightforward. If you're going to do something like that, if you're going to be concerned about things like this, put a short lag on the stream. It doesn't even have to be very long. 1 minute, 2 minutes. Because then that would have been plenty of time in this situation for them to realize, oh, there's a thing on the screen that's not supposed to be on the screen. Cut that part of the feed where it shows before it goes out, blur it, whatever you can do. And then that doesn't interfere with our ability at home to continue to be fully informed about what's happening in this courtroom. But it also protects the defense, which is legit. Because, I get it. There's no point in having these orders if the orders are just going to be, oopsie, oh well, it's out there anyway. I get that. What do you guys think? What do you guys think? Does that seem crazy, unreasonable? I think that seems very proportionate, very doable, very feasible, accommodates everybody's concern. That's what I would be suggesting if I was in there dealing with the situation. To the extent the court isn't going to just accept that, sorry, it happened, we'll try to do better. Because if everybody is already trying and it's happening anyway, then trying isn't good enough, right? So if trying isn't good enough, then just do the short delay. It's fine. We get a little bit of a lag at home. We're not actually in real time. We're like 2 minutes behind. Who cares? Who cares? That I can live with. The only like next kind of backup thing I could see would be, you know, just greater delay. Still have the cameras in there, but, you know, hold it longer. We get it the next day, we get it the night, whatever. I don't like that as much. It just doesn't seem necessary. It's overkill. You don't need that much time to know there was an inadvertent showing of something on the screen, and so we need to cut that part. You know, I didn't watch Lori Vallow. I thought didn't they take the yeah, now I'm all like lost. I didn't watch the Vallow case, any of them, really very closely, and particularly with Lori, I get lost on which one we're talking about. You know, you had many trials. So I don't remember for sure if that's what they did, but it wouldn't surprise me. It's not that uncommon. I'm pretty sure they did that in Depp v. Heard. It was just like a couple minute lag. But you say, Carol says Arizona was a 30-minute delay. Yeah, we can live with that, right? We can live with that. 30 minutes. Who cares? Who cares? I'm not out here trying to get the exclusive report anyway, you know, the be the first to report it. They don't have live tweeting in the court, so we don't necessarily have that consideration either. But like that's the complaint. Oh, if I have to wait, then I can't be first. Oh no, I'd rather be best than be first. Yeah, I think the time delay will solve it. But the defense wants no cameras. Yeah, we know it. And they're going to be banging this drum as long as this case continues. They're going to be trying to get the cameras out. But we have a right to know the information. The entire incident was public on TV when it happened. We have a right to know and see. Yeah. I just think it's smart. It's smart. Yeah, there's no constitutional right to have the cameras in the courtroom, but the whole process, it's going to be so much more legitimate, perceived as legitimate when we can watch it. When you do it behind closed doors, everybody naturally wonders, what are you hiding? As far as going to the harm of all this as well, I mean, I can't help but hope that this has a little impact on the judge in terms of, you already let the whole courtroom see it. And we don't know what the thought process is behind why it's fine for the courtroom to see it, but not the cameras. This is just, this has not been articulated, explained, the logic behind that distinction. If the courtroom's seeing it, it's public. Keeping the cameras off of it is just making it harder for us to access for a reason that really isn't clear. It's not clear why it should be harder for those of us who can't be present personally in the courtroom to be able to see what is public in the case. And so I hope that maybe this inspires the judge to question the wisdom of that distinction. Why shouldn't we at home see everything that the courtroom is seeing anyway? And if there are things that you're saying these exhibits are just too inflammatory, they're too incriminating, just whatever it is, then you just, I guess, keep them entirely non-public, at least for now. But this whole, like, the courtroom gets to see it, but you on the cameras don't, I don't get it. I don't get it. And the argument basically was, here's the extent of the logic we've gotten on that so far is that if the camera captures it, I've already ruled you're not going to be able to make copies of the exhibits, and you would be able to de facto make copies of the exhibits by doing exactly what happened here, screenshot the screen, and now you see what the exhibit is, and you effectively have a copy. Okay, but Why aren't we making copies anyway? Why is that such a problem? Why is it such a problem to be able to have a copy of the exhibit? I thought I heard something, but it was just my imagination. So yeah, this whole process is going to be a learning process for everybody. And I don't expect them to be perfect. I expect them to stumble. I do want them to err on the side of transparency. But as the learning moments go, opportunity to kind of reflect on some of these earlier decisions and whether and why they make sense anyway. But it certainly should go to the proportionality of whatever he decides to do, that the whole courtroom got to see this, and the text of it is already out there. So literally the only thing that the cameras got is that they were able to show us the condition of the note, the time that Lance took the photo. And that's something that everybody present in the courtroom would be able to tell us. It was intact, unburned. They'd be able to report it. So whatever he's seeing as the problem here with us being able to see that, it seems like such a just tiny, minuscule difference from the fact that we can know it anyway. We can be told the pertinent information. We already know the contents. It's somehow worse because we can see with our own eyes that it's intact, the way that the people in the courtroom already know and saw and can tell us. This is one of the reasons why I you know, the more you try to be secretive, the more it just drags you into this morass. We've taken so much more time dealing with what we can see and what we can't see and so forth than the process that this hearing is supposed to be about, the substance of the hearing itself. It seems like a really unnecessary complication. We're well over our 5 minutes, of course. Well over our fine minutes. The remedy should be the death penalty taken off the table. That won't be proportionate. Defense probably won't ask for that, but maybe not this time. But they'll ask for that, I'm sure, plenty of times over the course of the case. Yeah, invest in a video switcher with a monitor. Or just show everything because it's an open court. I'm just saying, one option, you know, we could respect the constitutional principle of public access. We could do that. We could do that. We could recognize the significant value of letting the public observe and monitor what is happening in criminal cases, basis for charges, all that. We could maybe just do that. That's right, CH. I'd rather be best than first. But that's always kind of been our approach here, right? We're equality, not speed. I'm often late to the game, only getting to cases, topics, and things like that long after they're out of the immediate news cycle and most people have moved on to other things. I want to let it sit and simmer and explore, you know, research, all that kind of thing. Everybody can have a knee-jerk reaction, and that's fine, and that's fun a lot of the times too, but taking the time to go a little deeper, I think, has significant value. This is a good question as far as the trial, because I would expect everything at the trial is going to be public, with the possible exception of, again, the graphic videos, just because they are extremely graphic. But what's at stake by the time you're at trial is very different. The reason they're concerned about it now is because we're potentially, we're worried about the effect on the jury pool, the people that are watching and going to be called in to decide the case. And the more they know, the harder it is for them to be fair and impartial. But when your jury is seated and you're in trial, that's no longer a concern, or at least less of a concern. We saw from, I forget which case it was the other day. I think it must have been Estes. It was Estes. They're like, yeah, but if there's a retrial and everybody's watched it, that's going to make it harder. Well, this is a, yeah, I mean, kinda. But by the time you get to a retrial, you're generally speaking like a couple years from the event of the trial. A couple years have elapsed, not exactly fresh in people's minds. But also, the percentage of cases that you're talking about that affecting is extremely small. And then you still have all of these same remedies available. You could have just changed the venue in Rideau. Could have just taken it out of the county. You can just call in more jurors. You can do more thorough examination, all that type of stuff. So at trial, it's different. And I do expect we're going to see pretty much everything, but maybe not those videos because they are really graphic. And you just don't necessarily want that permanently out there, easy for everybody to find. It'd be kind of a repeat potentially of September the 10th, where whether you wanted to see it or not, it was all over the X feed. We saw real similar situation like this. Uvalde, the Adrian Gonzalez trial, that school shooting. There's surveillance video in the school. And, the incident, the response, there's some awful footage. And you can go find it if you want to. It is lurking in the depths of the internet. But you have to go looking for it because they didn't make it so accessible. They did not show that at the trial. It's not on the camera at the trial. So it doesn't get recycled, into the news feed because it's in big, high traffic sources. So that's what I expect. It's just a different circumstance. Much less concern about the jury being tainted because you already have your jury. Yes, here, no star chambers. No star chambers, no bills of attainder, no uncross-examined affidavits. Might be fun to look at the trial of Sir Walter Raleigh sometime. This was like the paradigm of kind of what America was responding to in terms of the tyrannical practices that earlier governments used, that were like, yeah, we're not going to do it that way. Not if we want to be a free society that is not governed by a tyrant. That might be fun sometime. The other option is to be in Indiana, no cameras within 50 feet of the state line. But we have to make sure we go through a big song and dance before about really patting ourselves on the back and getting ourselves a massive amount of credit for our great steps we're taking towards improving court transparency while we are below the radar, actually significantly diminishing court transparency. Because even though judges can let the cameras in now, they don't have to. It's up to them. And the audio recording that used to be public that anybody could get now is not. We're going to take that away. You gotta make sure you include that part first. You need a healthy heaping of hypocrisy to really pull off the Indiana method. Yeah, I think this is a really great example, recent example. The Carmelo Anthony case, no cameras makes it harder for people to understand the result. I would love to be able to examine the Carmelo Anthony case, but I can't because I don't have a good sense of information, a good source of information. I don't have a direct source. And so I'm just very hesitant to have an opinion about something that I don't have good knowledge about. And the judge himself, late to the game, but he did that interview after the fact where he said, in hindsight, he really regrets.
Noting the presence of counsel in all parties, and where we left off as the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted.
You don't want
the
us
request
to
for
see
today.
your
That
own
was
case?
sort of the chain of events.
Your own
And
witness?
that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened
Forensic
yesterday.
hates Novak so much.
The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed.
Agreed.
When the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter. Or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank
Thank
you,
you.
Mr. Novak.
Thank you very, very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to here order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist.
Or DNA.
And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, yeah, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing, deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after a long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And I'm just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
Judge Graff seems especially soft-spoken today. Yeah, that's the irony of all of it, isn't it? Is the camera person who was on it faster than anybody else. The findings are a tell, you know, the findings that he made are a tell. Acknowledging it happened, but also not blaming the media. It's already public. Whole thing wasn't shown on the screen, and it was shown to the courtroom anyway. It's de minimis, this problem. 30-second delay, I can absolutely live with that. And sure, that seems appropriate. It kind of seems like a smart thing to do anyway. Because yeah, stuff does happen. Remember that video of that guy jumping over the bench and attacking the judge, that one down in Los Angeles? Can you imagine? I mean, don't expect that to happen in the trial. But just, you know, anything can happen. Witness comes out of the chair at the judge or something. Good Lord. Yeah, that's why you have the ability to kill the feed. Yeah, I remember that. It was in Las Vegas. And the judge looked remarkably like Judge Gohl. It was. I remember that case. That was actually a sadder case than I think got a lot of credit for. That was the one with the guy who... His long history of mental health issues, everybody knew. He had had a lot of success in the past with the mental health court, the structure, the supervision and stuff like that. Went many, I want to say at least 2 years, you know, without having any problems. Successfully completed it. But, you know, then you're no longer in the program. The structure is gone. He declines. He's back in court. He's clearly decompensated, and we get that. Our mental health system is extremely broken. Yeah, I think that's the big takeaway from those findings. No harm, no foul. Obviously not good. It is a technical violation of the order, but it wasn't deliberate, was dealt with, didn't really hurt anybody. And there's ways that can protect against that in the future should they decide to pursue that. It does seem logical. It does seem like a smart precaution to do. Just delay the feed slightly. Here, will never not share this comment anytime I see it going through the feed. A stain on the bench. An embarrassment to the judiciary. This is what I believe too. Maximalist. Now I will, okay. Now actually I will argue against myself. I will moderate my position. There are certain kinds of cases that I don't think we need to see. Certain cases I think we don't need to see. Certain things involving children, certain things involving personal, private, mental, physical health stuff. But those are very, very limited exceptions. So I'll back off of my maximalist position when forced into the corner by a greater maximalist than me.
I'm almost done. I appreciate the party's patience.
Yeah. Goal makes Bev look like the judge you want to draw.
Rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions. And I want to give this the full analysis that it's due. So thank you again for your patience. All right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied.
Yeah.
The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you.
Don't like
Turning
it,
to the
Judge.
defense, if you wish, you may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Gernander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge.
We can't
This
hear
is
you.
in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution," close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So
No.
if he's lodging a standing
reserved.
objection now, I think he's waived it, or he should be stopped from asserting it, given the
He
circumstances.
specifically reserved it.
I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burt. And before I have you call the witness, just want to make sure that the media well, I'm not sure if the media needs to be heard on Mr. Grunander's response. No, Your Honor. All right, thank you. All right, Mr.
No.
Burt, you may call your next witness.
Thank you. Call Miss Oliver.
That is not what happened. They said very specifically they were reserving their right to object to the specifics of the testimony if it went beyond the scope.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer, so I want to make sure your voice is projected. Thank
Don't
you.
know if I got her
What do you
first
do
name right,
for
but
a
I
living?
tried.
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
All right, they have it with the C, so I guess I'll change that. We're having an argument off the record again. Seems we don't get to hear it. We don't get to see the exhibit, and apparently we don't get to hear them talk about it either. I'm just so done with this. This is ridiculous. I mean, yes, they're having an argument, it seems. Yeah, this is my guess. Is some kind of voir dire about this exhibit. But I still don't know why we wouldn't be able to hear this. Let's go back to yesterday and see what this exhibit was. This came in through Officer Baumuina. Exhibit 30 was the DNA testing on the rifle, the cartridge case, and the cartridges. We already know all the results. They were all mixtures, but Tyler was the major contributor to all of them. The mixtures were different amounts. The highest one was 5, which is kind of a lot. The lowest was 3. 3 to 5 people on all of these.
For instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits.
So
And
media.
I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors at council table and podium. Any clarification on that?
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. You cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider that the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns.
What's this going to do
Mr.
to
Burke.
his previous ruling about she's going to get to see the zoomed-in video?
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct? Now, when, you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30? Page 8.
So
Were
far, it
certain,
seems
DNA
highly
samples,
cumulative.
Consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in plaintiff's exhibit 30.
That was vague, Bert.
Were all of the
It's
samples
unclear.
you looked at there mixed samples?
I
Yes,
referred
they were all
to
mixed.
My tables in my report.
Sure. Go to page 2, please.
He used a they that was is completely
Go
ambiguous.
to page 3 and 4.
3 and 4, please.
Unclear to me if there's extract.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
That seems vague.
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language?
Do you have one in mind you want to
use
ask
in your
about?
report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify it, essentially what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please?
Yeah, we don't get to see the exhibits today.
$136.
Been waiting for the cumulative objection, but we haven't gotten it. We've already heard all this from the other analysts. We already know.
Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page.
Yes, good qualifier there. We don't get to see the exhibits.
So they're
Because
making
the
recommendations
camera
here
was
as
on
to
the ball.
how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that,
Correct, yes.
right?
Come up to bring some chaos.
And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yeah, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page,
Oh, look. Defense is going to go at Lance.
4.
That's going to
which
be
is
the strategy.
table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the
She's
swabs
being
of
more
the
careful with the
bolts of
language
the
than he
rifle.
is.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay.
He's
Could
really
you
not
go
because of phones and
to the
location,
next page?
but we will have to see how that plays out.
Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go 2 page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct,
And some of the evidence had a 17 allele
correct,
at that location.
correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison, so it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct,
But the bottom line is you're comparing alleles one against another.
correct,
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
correct,
And again, measuring only length.
correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection, relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here and the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection, relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and
Goes to weight.
therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection, and the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out, so it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends
Again,
on,
objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burke.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say, the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP.
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you
the
bring up
question could be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh whether we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
At that point, you should be done, right? We swear. Absolutely. It's super fast today. No chance it could go past lunch.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
That's a
There are
well-structured
several locations I'd have to refer
question.
to my report.
Okay, would you look at your report? And this
Have her
looks
send a
like
long
report
list.
number- or exhibit
State a
number
long
30.
list
We can pull that up just for
Of the
witness.
places on the gun where she found support for inclusion of Tyler Robinson, the trigger guard, the bolt, the stock, like all of it.
Thank you, Kimberly.
McBride knows how to persuasively deliver information. All in how you frame it and present it and package it. And getting a long list here.
We had it for a minute here.
Going to be impactful when he does that in front of a jury.
Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions.
The cartridges is more significant than the gun.
Let's look at page 5, please.
Because that is where you can draw some time inferences. It was deposited
And
before the
calculation
bullets were
number
put in the
3,
gun.
Exhibit 1.3, do you know where that swab was taken from?
After the last time the gun was
Refer back to
used.
page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
The 1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6?
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of two individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together, is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person, can't state it's infallible, can't state there's a 0 error rate, and you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you, that's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused? All right. Thank you, ma'am. You may step down. Anything further from the defense?
That was pretty repetitive, wasn't it?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right, in regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
I understood that too.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties? Okay. I'm just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader, and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state, now my understanding there's no audio on this surveillance on 12.1.
Yeah.
Is that correct?
It's silent video.
All right. All right. So let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured, the screen, in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right.
You know, part of what I don't like about this, part of why I don't like...
To the state, just let me know. If you're ready, let's go ahead and play it now.
This whole watch in the courtroom but can't see it on TV. You are creating privileged access to the evidence in the case to those of whom are present in the courtroom. We have an extensive body of First Amendment law, the public access issues that makes it clear the media is not on a separate footing than the public. We all enjoy the same rights. They don't have greater rights than we do. But they sure do enjoy privileged access to the courtroom, don't they? They get their own special passes to get in, and then whoever, whatever room is left, the public gets to take up. It's not like there's just one big line out there of public and media, and whoever is first come, first served gets in. So we're kind of de facto creating the system where the media gets the privileged access to the information, and that's really contrary to not just the principle behind the First Amendment, but a lot of the explicit language of this case law. The media is no better than we are. That's right, CH. And if they don't get their privileged access, Dateline will just cut in front. They'll just cut right in front of the public so that they can put out some trash piece of information and take a seat away from somebody who waited overnight for several days to get in to see a verdict. That's right. It's exactly what happens. Yeah, here's the thing. We still weren't going to see it. He said specifically yesterday he was going to publish it to the courtroom, but not to the cameras. So there's nothing that's changed. This is always how it was going to be. It has nothing to do with the inadvertent. The audio only is silly because there's no audio. So yeah, this is the video. Can't get the right thing. The chat moves too fast sometimes. This is the zoomed in video of the surveillance footage, specifically the rooftop, is really what they wanted to see. They're going to show the whole video, which is probably about 8 minutes. But the alterations where they're able to zoom in and enhance and see in greater detail, because we watched the unedited one in open court, which is fine. But you can't see the part where they're telling us the guy's running across the roof, to get into the corner, in the prone position, and then is in the prone position for a while. and then after the time of the shooting runs to the other corner and drops off the side. That part we've seen enhanced because the FBI released that. But the first part, the part preceding and during the time of the shooting, that enhancement we haven't seen. Isn't this riveting? Isn't this meaningful access right here? Oh, good Lord. Still like the judge. Still prefer him to so many of the judges that we've seen. Don't expect perfection. But this is just so illogical. I can't say it's illogical because I don't even know what the logic is. There just is none. Really hasn't been stated. I just don't get it. I don't get the thought process. I guess so we can't screenshot the copy, but what is the harm of that? If everybody in the courtroom can describe it in great detail, sketch it, etc., they could go back to their studio and make a whole digital recreation, representation of what they saw and publish that. Would that be better or worse than just seeing the original ourselves? Don't get it, Judge. Let me go off camera real quick and I'll see if I can find him. I'll see if I can find him. Success. I had to go steal him from Jeff, but we found him. Hey, bud. He really is an awfully sweet cat. Very cuddly for the most part. Of course, probably not right now. Right when you want him to be, he won't be. Did I dare say that to you? I have been, I've enjoyed learning about the personality differences of the boys versus the girls. These aren't my first cats. I did have a cat, another cat that just decided she was going to stay with me for many years, and then had her for, I don't know, 16 years or so. And that was a girl. So I got to know the girls pretty well. I've had girl and boy dogs, and I've been very impressed at the differences between them. But I've never really been around boy cats before, so getting to know what boy cats are like has been quite a joy. My kind of general description of the differences between the personality of the male and the female. This might be broad animal across animals, but see it with the cats, see it with the dogs. The boys, their experience, their intersection with the world and with the people and everything is, I love you, I love you, I love you. The girls, their intersection with people is, you love me, you love me, you love me. That's the difference. Best way I can think of to describe it.
All right, and that concludes the playing of Stacy Exhibit 12.1. Video transmission may resume. Just let me know when that is live. All right, thank you. Does either party need the benefit of the record?
It's your lunchtime.
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right.
Adjourned until September 1st. Till we come back in 2 months after we've gotten our extensive written briefing, almost 100 pages of briefing, 88 pages of briefing total that he authorized. That's going to be a big stack of paper to look at. Is anybody shocked? Is anybody shocked with what we got today? More of the same? More of the same. And the thing is, you know, I just want to maybe take this opportunity to highlight the point that I've made a couple times over the course of this hearing vis-a-vis strategy for cross, and how I'm just such a firm believer that the short, punchy, get to the point, get in and get out cross is so much more effective than the meandering, exploring, going down rabbit holes, coming back thing where you kind of lose track of what matters and what doesn't. To me, the most important point that the defense brought up in this examination of this expert was that they can't say definitively that somebody's DNA is present, period. It's not scientific to do that. They can't say with 100% certainty. They can just say, well, it would be extremely unlikely that it was somebody else. Somebody else, unrelated, unknown, would contribute this. That's kind of the bottom line, isn't it? Was there more out of this that was really super, super helpful. Maybe that there are other techniques available that could help to exclude him and they didn't do them, period. The next gen stuff. Here it was. I put a star on it. You can't say, for example, the statement, Mr. Robinson's DNA was found on an item. That claim is not scientifically defensible. She agreed. That's powerful. It's accurate. It sounds really, really significant. But it's just because they can't say to 100% certainty, they can just say it's extremely unlikely that there's an alternative explanation that involves unrelated people. And that was like in the middle. You know, we were quite a bit in. More of this language stuff, and I couldn't even quite gather because his questioning was very vague. When we talked about the consumption, samples were consumed in the analysis from this list. 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, 5.1. We know from the other analysts that they always consume the swab. So is that all you're talking about? Or are you saying all of the extract was consumed? That's not clear. It wasn't even clear. Might have been a really good point if it was clear. There's nothing left over for the defense to retest. If that's the case, that point didn't get made. Doesn't tell you anything about the time. But all this did then is, from my perspective, it opened the door for the state to get some kind of more damaging stuff out there. You know, remind us, oh yeah, that fired cartridge in the gun, that's only a 2-person mixture. It's one of the best samples that they have on probably the most significant piece of evidence in all of this. We expect his fingerprints and his DNA to be on his own gun. We expect his dad's to be there. Didn't hear anything about Lance's being on it. Didn't hear anything about Lance's DNA being on any of this firearm stuff, just on the Dremel. No support for inclusion of Lance on any of these items. And, you know, to the extent it does matter, Tyler's DNA is in the protected part of the receiver after disassembly, parts that you have to take the gun apart to be able to get into. Everybody saying he's not a gun guy, didn't disassemble the gun, nothing like that. Sometime he did. Sometime he was in the inner workings of the gun. Or somehow his DNA got in there. As a major contributor. I don't think that helps. I don't think that helps at all. We didn't know that before. I don't think we'd heard anything about the protected areas of the receiver. Might be in the report, but I don't think they'd talked about it. So is DNA inside the parts of the gun that you have to disassemble to get to? He's kind of starting to sound more like a gun guy to me. They recovered other long guns from his house. He's talking about hunting trips, hunting and camping. He's got the targets with the not awful groups. Kind of sounding a little bit more like a gun guy, maybe not like a hardcore, but certainly more than somebody who's never hunted, somebody who's never fired a rifle. But otherwise, this was all just a repeat of the same basic criticisms that we already heard from the first expert that we already know is coming. Really think this could have been a lot more punchy and more impactful, particularly given that since this is not going to have any material effect whatsoever on this hearing, on the outcome of this hearing and the probable cause determination, because all of this is going to the weight of the evidence, we think it's unreliable, but the judge doesn't get to consider that. He assumes it is. He assumes it's good science, good conclusions for purposes of this hearing. It's for the jury to sort out criticisms of that. It's not, none of this was about this hearing. This was for us, audience, doubt. So given that, this could have been so much more impactful. Don't know. Don't know how much any of that landed. Well, Judge did good, at least in the sense of he did get us out before lunch. Maybe just a few minutes. But we'll take it. We'll take it. NJ Kathy's joined the channel as a new member. Welcome. Welcome to the channel. I know you've been around, been a member before. Welcome back. Animals Over Human recap retainer. Thank you so much for that. Yeah, man. It's like, what are we even going to say tonight? Go back and rewatch whichever day it was. I don't even remember now. I'll have to go back and check. No, because remember, we're still going to sit down and look at the information. Today is like the small, we have a small recap, not a whole lot to add, but then we have the summary of the week as a whole and where we've ended up. The Real CH, hope nothing weird or infuriating happens today as I open the stream from the weird and infuriating factory. You might have contaminated us. No, you didn't. That wasn't your fault, of course. Has it occurred to the judge, like, why did we get punished? Why did we get punished for Mr. McBride and the camera person? Why did we suffer the consequences of that? They didn't. We did. That was it, Judge. Why are we catching strays over here? Because we're watching the live stream, trying to be good citizens. Be informed about the case and the process. Try to make sure we understand it all. Why are we being punished? I gotta wonder if that's crossed his mind. You're punishing us, Judge. Nikki Exposed, you're my favorite CLE course. Thank you. Wouldn't that be great if we could get credit for these live streams? Oh, so this is my CLE reporting year. In Washington, we report every 3 years. And so that can just be a thing. If you ignore, and then you're like, you get the warning, you send out a warning email like 6 months before. I think they sent it out in June. Just a reminder, it's your reporting year this year. Then you're like, oh my Lord, you have so much time you have to get. And the problem is you might go to, say, a weekend conference or like a long weekend conference or something like that. 3 days, you're like, yeah, I'm gonna get a massive amount of my credits done in this weekend. No, because they chip away at the time you actually get credit for. So you only end up with like, you'd think, I'm sitting here in this room for like 8 to 10 hours every day, but I'm only going to actually get credit for maybe 4 to 6 of those hours, Anyway, it's my CLE reporting year, so I do have a little catching up to do. That's fine. That's fine. But it would be super cool because we get credit for if you're a presenter at a CLE, you also get credit for that. The time that it takes you to, put your presentation together and stuff. If I could just send them my live streams. Here you go, Bar. Here's my credit. Autry's fake accent has joined us on the channel. Thank you so much. An American Dreamer 5867 gifted someone a membership. Thank you so much for that. Very generous of you. User XR numbers. We saw this before. How is it not an ex parte communication? Because they're having it in open court. They're having the conversation in open court. Ex parte is when it's behind closed doors and outside of the presence of the other side. It's basically like a private communication with the judge. That's what ex parte is. They'll do private conversations with the judge, like emails, letters, stuff like that, but you copy everybody. That's what keeps it from being ex parte. It's really about the notice to the other side. Michelle 8190, I appreciate the judge taking the showing of the exhibit seriously. There was so much BS in the YSL trial with the prosecution intentionally showing exhibits. It created a lot of questionable problems. This was an accident though. I didn't know that. I didn't watch YSL other than just like that little brief bit around Brian Steele getting threatened with jail for calling out the judge's ex parte communications with the prosecutors. That like, didn't that ultimately end up getting the judge disqualified and stuff? I mean, that whole thing, that was wild. That was wild. That was my, I mean, I've heard about Fulton County for a long time. Who hasn't? But that was just kind of like my first, oh, okay, I get it. I get how this is not just a Fannie Willis thing or whatever. Like this is very big and systemic. What kind of judge does that? That was insane. I mean, yeah, I'm with you. I do. He should take it seriously, and also just complying with his orders. Of course. You can't be making excuses for people to not comply. You have to be a little bit no tolerance, or people are really going to push the boundaries. So you can't do that. I appreciate that too. I just don't think this was particularly proportionate. Because yeah, it was a mistake. It's an accident. Far less problematic way to deal with it. Just do the delay, do the lag like they suggested. And instead we get punished at home for something we didn't cause. We didn't cause that problem. King the Conqueror 2025. Today is the day. The Egyptian planes, the French Foreign Legion, Israel, U.S. military involvement will finally be exposed. I hope you are not crying into your pillow tonight, King the Conqueror 2025. I'm sorry for your deep existential disappointment that today did not live up to your expectations. I feel you. I feel you because I am, as I've said, I'm having to grapple with the many layers of complexity that Mr. Novak, Mr. Burt, Judge Graff, these people I've just been real boosters for, such a big fan. Ooh, this week is shaking that. I got some disappointment I'm going to have to process. So I really feel you. I understand what you're going through. Gingerpuff 764 gifted 5 memberships. Thank you so much for that, Gingerpuff. That was super generous of you. User XR9X. I disagree. That was an ex parte conversation. The defense was conferring as the judge agreed they could do. They can't follow the conversation. The defense was conferring between themselves. Did I miss? I might have missed something. Otherwise, I'm still not seeing an ex parte. This is a conversation happening in open court in front of the other side. If the defense is conferring privately amongst themselves, they do that. I mean, they're the defense team. They don't have to share their internal communications. It's privileged stuff. So I might have missed something. If I did, I apologize, but I didn't see anything that gave me concerns about something ex parte happened. Sorry if I missed it. Bass player 2111 IFY. But Andrea, what about my jury pool? Look, I don't want to minimize. I really don't. Because I do appreciate these points that were kind of first really elaborated well, I think, in this kind of context in the Koberger case. When we had the hearing on the motion to change of venue and Dr. Edelman testified at that one, I understand that there are real challenges with actually being able to suss out bias, and that can get really complicated too in circumstances where judges are more restrictive with voir dire. They limit what you're able to do. They limit if you're even able to do it. Some places the attorneys don't do direct voir dire at all. It's all through the judge. But even in the best case scenario, when the attorneys get to ask all of the questions, yeah, I appreciate there's a double bind kind of situation where how can I ask you about specific things that have been reported to find out if you know it without alerting you to this information that I think is so prejudicial that I'm trying to find out if you knew it at all. Like I'm going to poison the well in the act of trying to filter it. And I also get the problem. One of the things that came out of that particular hearing that made so much sense to me, and like, yeah, this is exactly how it works, is just the way in which these questions get answered. You ask somebody, what have you seen? What have you seen about the case? And they're like, well, you know, I've seen this. But there's a whole bunch of stuff that either it's like not at the front of their mind, or they're just not inclined to like list every single specific thing. But then you follow up, you know, you're like, well, but what about this? And they're like, oh yeah, I saw that too. Oh yeah. You know, like they need the trigger of the question to remind them. So I really am. I'm very sensitive to all of these issues. I'm sensitive to the fact that the standard that we have, where basically as long as a jury says, but I can be fair, I've seen everything about the case, totally think he's guilty, but I'll keep an open mind as I see the evidence. That person's qualified to be a juror. So I really don't want to suggest, you know, that these are insignificant issues. They're unimportant. They aren't worthy of our consideration. They definitely are. It's just that I'm not real convinced that they're insurmountable or are going to be in this case when we're working with the people and the process that we've seen so far, when we're working with these individuals, this judge in particular. This judge has bent over so far backwards to give the defense every benefit of the doubt, every opportunity. I just don't have a lot of reason to be concerned at this point that once it gets to jury selection, he's going to drop the hammer and be like, no, I'm not going to let you do what you think is necessary to sort out bias. And the defense is going to have their consultants, they're going to have their experts, their Mr. Edelmans and stuff like that. A lot of this stuff has also been like focus grouped and tested out. They've figured out strategies and things like that. So they're going to be about as well equipped to deal with that situation as you can be. So, I mean, to the extent I minimize it, that's kind of why. And it does. It always goes back to the issue that this is not first and foremost in everybody's attention. It's easy to think it is when we spent all week, many hours, focused really intently on this. Most people didn't do that. Most people probably paid more attention to Taylor Swift and Harry and Meghan and the World Cup, all of which had like big, significant developments this week. What else happened that I missed? I mean, I'm sure there's plenty of things, but they're just kind of some big pop culture-ish kinds of things that were out there. The Phillies won yesterday. That's great. It's great. The Phillies won again. I'm becoming hesitant to mention Phillies baseball anymore because it seems like every time I do, there's a disaster that day. The game is just like, so today will be a test, but I do that with caution anyway. But yeah, I know. I know, my jury pool, as if, you know, they're helpless kind of to deal with all that. And they definitely aren't. It's a hard problem, but they're not helpless. The stay-at-home juror. I signed up to partake in a jury consultant focus group. Should be interesting. Hoping to be helpful. Pays $150. Sounds fun. That does sound fun. I've known people who have participated in focus groups like this. Cousin of mine down in Southern California was doing that for a while. Was like doing a lot of focus group stuff, and I imagine it would be fun. You know, I would like to see that. Might actually be as close as I would ever get to serving on a jury. Ellie B from Tennessee. I worry that when sentencing time comes, this judge will not have it in him to lay into Tyler like some judges do, expressing how horrible the crime was, etc. Judge is too soft in his voice. Yeah, I don't know. I got to tell you personally, I'm not a huge fan of those types of things, you know, the judge like telling the person how awful you are and, you know, yada yada. One, just because I don't think it's really comports with the judge is supposed to be objective and dispassionate and stuff. And yes, I realize now the process is over and the judge has all of the information. But it's just like when you're expressing this deep antipathy and hatred and condemnation and stuff like that, it's like hard for me to think that just came up spontaneously at the right moment after, you know, you received all your information. So that's part of why I don't like it. I partially don't like it too because this case is going to be different than most cases because it's death penalty. We have mitigation phase if he's convicted. Sentencing, that's the whole point. State puts on evidence of aggravating things it thinks aggravates, you know, makes the situation worse than the average crime, makes him worse than the average criminal, and the defense does the opposite. Why he's, you know, not the worst of the worst. This crime isn't comparable to, you know, the types of crimes where normally, you know, they're just like so egregious that that nothing, you know, short of death could possibly satisfy the retributive element of the sentence. You don't normally have that in your average non-capital case. I mean, you get to make arguments, but it's not going to be as in detailed. It doesn't require the judge to make specific findings like this will. You know, he's going to have to find, well, not him actually, but the jury would, you know, find specific aggravating, mitigating, and decide what the sentence is going to be. So I mean, just because of that, the judges who are doing this, I think, are rejecting the whole person. And I mean, you know, I guess they're entitled to do that. I just don't think that that's wise. I don't think that's a wise way to deal with it. Because yes, people are very complex and there's so many different motivations and factors that go into why people do the things they do. And so the just condemnation, you know, what you did was horrible, you're horrible. I don't think it's accurate, but I also just don't think it's helpful as an attitude. Because if we don't, to some extent, have our penal system, prison sentences, all that type of stuff, the consequences of a criminal conviction, if that isn't at least somewhat tethered to rehabilitation, why are we doing it? We have to have one of the goals being trying to make it so there's less crime. So that people who committed crime will not commit more crime in the future, because we're not throwing everybody in jail and throwing away the key. It's not a life sentence for everything. For all that you know, we have our serious mass incarceration problem. And so if we don't focus on the stuff that gives us those seeds of potential for rehabilitation, then to me, it's very discouraging to the whole system, and particularly when that's being expressed by the judge, who's the voice of the whole system. Very influential. So his attitude is, I think, likely to be contagious when it comes to that kind of thing. So this is not a right or wrong thing. I'm just sharing my perspective to kind of, add to yours, which is perfectly valid. Perfectly valid. And I guess what I should say is that in a vacuum, that's really kind of my issue, is not like saying things like this. Yes, judges can and should condemn the crime and the terrible choice and the impact that it had. Like, all of these things should be highlighted. That's important. It's just a failure to recognize the other side. The what could have been different. That's what to me is a powerful sentencing, is when the judge is expressing just what a tragedy it is. Because things could have been so different. And there was so much, we've seen already, like, it seems like there was a lot of potential here. Good family, no criminal background, in the electrician training. Like, he was seemingly on a good path. And that's part of what makes it so tragic. I don't know if this judge has fire and brimstone in him. I don't. I mean, he has to be circumspect at this point. So we aren't going to see it. But when it's the right time, is he going to have it? I don't know. I don't know. I guess I'm interested to see Judge Graff's. We get to sentencing. If Judge Graff's Old Testament comes out. Tammy 32, he hasn't pled yet. If he pleads guilty, then penalty phase. Would the penalty hearing have a jury in Utah? I was actually thinking about this the other day, and I'm like, I need to research this. I don't know. I think so, but I need to check. The whole issue is if you plead guilty, then you've taken, you don't need a jury verdict on guilt or innocence. But in death penalty, normally you have the right to a jury to decide the aggravating and mitigating factors and to recommend death or life in prison. And so do you waive that by a guilty plea automatically? Not sure. I don't think so. I think you would have to specifically waive it. But I literally was thinking about this. Like, I need to look at the case law and whatever on this one. And it's been a week. Haven't done that yet, but it is a great question, and I want to know the answer too. So I do have a little note to myself to look that one up. Crashman von Stink Putin. The text of this entire letter was made public in search warrant 3217131, Lance Twig's Apple account earlier this year. Wish the state remembered this. Fortunately, the media lawyer did. Who got in their ear? Was like Andrea Burkhart on her stream was screaming, search warrant, search warrant. No, I'm not. I'm not going to aggrandize myself. I'm not the only person who knew that this was already out there in a search warrant. Lots of people knew that. So just apparently not the lawyers until this morning. Mara W 8658. Wouldn't it go to unfairness to have all but one day of trial made public when it's their witness is not? Essentially, that would be worse for Tyler, not better. This is exactly my thought process. It's the defense's witness and the defense's exhibits. So the remedy is we've seen the overwhelming majority of the state's case. And then now the last part of the defenses we're going to be restricted from. I just don't get the thinking sometimes. I really don't. We got punished. There's less of a public record of the defense's position at probable cause. Like, how How is this logical? Fortunately, this isn't like an error, an appeal kind of thing, because it was invited. This is basically what the defense asked for. Take the cameras out for today. Well, it was a limited taking the cameras out for today. Yeah, I don't get it at all. Mark Line, 1967, taking the cameras out of the courtroom would be a gift to conspiracists and a punishment to the Kirk family. Yeah, it's punishes nobody but the sincerely interested people who aren't in a position to go wait in line. Apparently, I saw, I'm trying to remember who it was. I think it was Nate Eaton. I think it was Nate Eaton was saying yesterday he couldn't get in. He showed up at like 5 in the morning or something. Line's already past the point where you're going to be able to get in. People were there since like 11 o'clock the night before, midnight the night before. That's what it was like in Delphi. Guys, this is the Delphi circus. So if you're not willing to endure the trial of Delphi, you don't get to know what's going on. It seems very counterintuitive to me. Kyle Cowden, a quick description of the next exhibit with an order prior to display would be a quick and dirty fix for the immediate need. Such a good point. Such a good point. We're going to have this new procedure where we announce when there is going to be an exhibit displayed. And by the way, you need to specify where is it being displayed to and can the camera capture it? So that we aren't just willy-nilly putting things on the screen. I think the problem with this is that the judge has asked them repeatedly, state your position on these 3 issues, and they can't even do that. For some reason, they can't even follow that instruction. He has to keep reminding them and prompting them, so I guess I'm a little doubtful that we have a good record that would suggest that's going to practically work. Works in the abstract, works in principle, but given who we're dealing with in the courtroom and their inability to kind of follow some basic instructions like that so far, would it be foreseeable that they wouldn't do it? Yeah, kind of seems like it would. Bass player 2011 IFY. I'll spell it out for you, Bert. Cut the BS and move your ass. Well, they never did assert their standing objection. Could have cut it off long before. I mean, I was kind of waiting, honestly. I was kind of waiting to see if the prosecution was going to yank the chain early. Be like, we've heard all of this already. This is all cumulative. I don't know why we're taking the time. Doesn't go to PC anyway. We got that frog boiled up into that boot from the Gold Rush, the old Charlie Chaplin movie. Before the judge finally realizes what Mr. Bird is doing, just one more, incrementally, and now suddenly you spend hours on stuff that doesn't matter. So then yesterday, less tolerant, cut it off earlier. Seems like he was receptive to cutting it off today, at least, to some extent. But the prosecution didn't push it, didn't ask him to. So didn't happen, but I think they could have. More aggressive prosecutors might have. Love in 2 limes. Am I correct that one of the defense attorneys asked a witness this week if they were aware that another bullet was found on another roof nearby? You are correct. That came out of testimony from a couple different witnesses. It was Bagley, I think, was the first one. Or no, it was Hull. It was SBI agent Hull, the lead investigator from back at the time, who testified it. But he also said they were able to identify it as having been cycled through a police officer's gun. And then we heard about it as well from, I think it was from Jen Faumuina, who kind of further elaborated that there was no line of sight from where it was found. I think it was on top of the science building. There was no line of sight to the tent, and it was also .223 caliber. So part of their basis, I would think, for finding it not probative it's not the same caliber as what was recovered from Charlie. So no real reason to think it had a connection to the crime. And apparently they were able to find out the source. It was from a police officer with a rifle, and dropped it. Nova Dexter, keep up the great coverage and breakdowns. Thanks so much. Thanks so much. Keep on showing up. And it's very, very encouraging. Very encouraging when we got lots of people to talk to. So appreciate that a lot. Good Mom 613. They're arguing procedure uses analysis. Yeah, and again, I don't want to minimize this either, because this is actually, it is very important. It is very important because the language relates to the truth claim. And the truth claim relates to what do we know versus what do we think versus what do we believe, like our epistemology. What do we know? How do we know it? All of those types of things. And those are really important because they go directly to what this whole process is about. Doubt versus certainty, reasonable doubt, overcome, not overcome, all of that. So I don't want to minimize the importance of that, because that has been the big problem with forensic science for decades, is them using language that is misleading about what these techniques can actually show and overstating how inculpatory they are. And that's why, you look at the exoneration registry and stuff like that. Bad forensic science, huge contributing factor to wrongful conviction. So, precision in language to not mislead the jury is very important. It's just that this really wasn't the forum for that. This wasn't the time for that, in terms of having a meaningful effect on the judge, on the outcome. PC is going to be found, even if there are some issues with how exactly the claims are stated, and it's not absolute and so on. And so it doesn't have to be absolute. Even a trial, it doesn't have to be absolute. It just has to be beyond reasonable doubts. It doesn't have to be 100% certain. So it wasn't for that. It was for us. It was for us. It was for the audience and for the public. But even to the extent it was for us, like it could have been done so much better. That's really my beef with it. Alexa Grote, 7469. If these are the defense team's best witnesses, it's not a good sign for Tyler. Yeah, I don't know. We just don't know what they have to work with. They are limited in what they're allowed to do at this preliminary hearing. Obviously, as we know, they wanted to call Lance. We're not allowed to do that. They just didn't have a proffer of anything Lance would say that would meet the standard and then justify bringing him in when he doesn't want to come. But we are starting to see the positioning, aren't we? Looks like Lance is getting positioned to be the source of the reasonable doubt. Kind of looks maybe a little bit like that. We'll have to see. Makes sense. Maybe Tyler isn't that sorry for getting Lance involved. Bass player 2011 IFY. While we are suffering through this BS, here are some of the ATF's greatest hits. Their experts can't field strip a Glock. They killed a wife and child in cold blood. Fully semi-automatic. And an AR can find 10,000 RPMs. Play it again, Sam. Yeah, ATF hasn't exactly covered itself in glory. And I must add to this list the illustrious Brian Higgins. Need I say more? Need I say more? That's the ATF. User XR numbers. Is the defense planning to blame Lance Twiggs? It certainly looks like. Now, okay, so let's talk about this real quick, right? Because this is now a alternative suspect, third-party culprit, that other dude did it kind of defense. That'll be worth looking at under the Utah law, Utah standards. Have to research it. Maybe I'll, it's another one, another good list, another good idea for the Substack is kind of what they would have to do to be able to specifically point the finger at Lance. And that's just because state standards vary when it comes to what they will allow, when they will allow the defense to point the finger at a specific other person as the defense, as, you know, their argument for reasonable doubt. Some states are more permissive. Some states are more restrictive. And the whole reason they do that is because they recognize that being publicly accused in court of being a criminal by somebody who is not a party, doesn't have the standing, the opportunity to defend themselves, and all that type of thing, that can be really damaging to somebody's reputation. So if you're going to do it, you just have to have a pretty good basis for it. It can't just be like, this guy was in the neighborhood, he's the murderer. Proximity doesn't really in and of itself tend to prove you did it. It just shows you could have. And so usually in states where it's more restrictive, it's that they're requiring you to get beyond this possibility and more into there's a legitimate reason to think that it actually did happen. Combination of opportunity, antipathy, recent conflict, you know, things like that, getting you a lot closer than just, you know, maybe his DNA was on the Dremel. Support for inclusion of his DNA on the Dremel. And it kind of, you know, they look similar, so could be him on the camera, for example. Although I think with the high def that we have from the parking garage, I don't think that's going to be, I don't think that's going to be feasible, but we'll see. We'll see. So it's, they would have to probably have a lot, you know, more than just it's possible that Lance was involved to really be able to point the finger at Lance. They'd have to have some kind of direct evidence that he was. And then all of this is assuming that there isn't already evidence available that can rule Lance out. They have his phone, full phone, location data, all that stuff. If he's got alibis, he didn't have to work that day. What did he do that afternoon? Did he talk to people? Was he gaming? You know? Got a pretty good record of people's daily activities in this day and age, because what happens? People wake up, roll over, grab the device. And it's literally part of the cell phone analysis now, the pattern of life analysis. They'll just go back through, you know, last year, last 6 months or whatever, and they will go through and see what your data shows about what your typical day looks like, what your pattern of life is, so that then they can identify when things are out of place. And the defense knows that, you know, we don't know that at this point, what's available in terms of, you know, potential rule out Lance evidence, and whether that exists or not. But that's a little different, pointing the finger at Lance specifically, than suggesting that there is reasonable doubt just arising from some of these complications about complicity. It's a fine line you have to walk. It's a fine line you have to walk. It's we talk about, lawyers talk about it sometimes, a distinction between the SODI and the TODI defenses. SODI is the acronym for some other dude did it. TODI is that other dude did it. Some other dude did it, generally speaking, you should always be allowed to do, because it doesn't implicate this risk of I'm pointing the finger at a specific other person So I need to have good reason to do that. I'm just saying, given this evidence, it's still consistent with somebody else being the perpetrator. I don't have to identify that person, just not me. You know, it hasn't definitively excluded alternatives. That other dude did it is more, you know, definitive. I'm identifying that person. So it can be a little bit of a fine line. That's where I think at a minimum, it seems like things are going, that we are going to be using Lance to try to create reasonable doubt, just because they'll be like, well, that's suspicious. That's weird. I'm not anywhere near as iconic Cardi B thing. That was a good one. I'm not particularly a Cardi B fan, but that is a really good meme. Bass player 2011 IFY. Burt is now 0 for 3 in his witnesses on his witnesses helping the defense. Give him a round of applause, chat. Yeah, I mean, this is one of the just strategic things that is always going to be at play. There's always risks with calling witnesses, even ones that you think are really super favorable. It's not zero risk, you know, but yeah, there's different degrees. These were not friendly witnesses, right? These are not their own. This is going to be the state that calls them at the trial. So they'll be the state's witnesses. They're not friendly to the defense. Their information is not particularly helpful to the defense, like the overall what they have to offer. There's just very limited selection of what they can say that's helpful to the defense. And so, you know, there's trade-offs with making that call. And if you're the prosecution, the smart thing to do, the strategic thing to do, is make sure it costs them. Make sure it costs them. And I feel like they pulled that off. Oh, I was so impressed with that question from Mr. McBride. It's just such a good example of how it isn't even always so much the facts that are persuasive and powerful in a case. It's literally just how they are packaged and presented. You can present them in so much more persuasive ways than others. That question about list the items for which there was evidentiary support for including Tyler Robinson, the parts of the gun, and then we just have this massive list: the trigger guard, the stock, the butt plate, the barrel, the scope, like, just the list is going on. You deliver it like that with a long list, that sounds really incriminating, doesn't it? So much more than if you just like, let's go through your analysis line, you know, bit by bit, line by line, and we spend forever talking about this thing, and then we move on, you know, we spend forever talking about the trigger and the trigger guard, and then we move on and we spend forever talking about the butt plate, and then we spend forever talking about the scope. And you just kind of, you know, everything is separated with a lot of information that probably isn't very compelling to most juries, and a lot of time. It just doesn't have the impact of cut all that other stuff out, put it in a list. Boom, 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 boom. And the impact is, wow, that's a lot. That's a lot. That's a lot of places on the gun where there's support, evidentiary support for inclusion of his DNA as a contributor. Yeah, I don't think this was a really good showing by Mr. Burt. Does make me question if that's just a factor of what they have to work with. OG Mittens. I'm no law expert, but language used was representative of victim, so it should be family only, not whole courtroom. Correct. The victim representative doesn't have special rights to view the evidence. Like, they don't have special access to the evidence. They don't have a backdoor to the prosecutor's office. Prosecutors, generally speaking, aren't necessarily going to share investigative details with the victims because it's not public information. And that's going to be additionally the case here, where there's also a gag order, where the prosecution has to be very, very careful about who gets non-public information because of the risk that it could end up out in the public sphere. And Erica is a public figure. So there's not really a universe where, you know, Erica just gets to go to the prosecutor's office, you know, and see it herself. So now we're dealing with it in the courtroom, and it's just a right to be present for what happens. But that's kind of at least similar to the right that everybody else has to be present. We also have a First Amendment right to be present. So I think to just avoid, you know, the special access problem, the law doesn't give her privileged access to the evidence beyond everybody else. But he bought into this argument that for her presence to be meaningful, it needs to be more than a butt in the seat. It'd be nice if he would apply that, you know, to everybody else as well. But, and so because of that, you know, present for what? Present for the presentation of evidence. It's not something the judge had to do. He has the discretion when it comes, like you said, to what gets published in court and how it gets published in court. So it was really just kind of a reversal about, you know, the decision that this particular exhibit should be shown to the courtroom or not. Not because she has a greater right of access, but just because he found that persuasive as an argument for why it should be generally shown in this context. I guess that's the best explanation I can give you. But I think that's the bottom line, is just she doesn't have a greater right of access to the evidence than any of us do, and we would be side-eyeing it, you know, if she did. 2, truth for liberty. Court sanctions should avoid penalizing the public. Hear, hear. We didn't do anything wrong. We are not the problem. We are not the problem, and we are the only ones who suffered a consequence today. YSD Films. Did prosecution have permission from judge to show the letter to the court? So why are they not the ones blamed in sanctions? Prosecutor instead gets Streisand effect on the letter, and we get sanction. No, I mean, he didn't have permission. He didn't have permission to display it to the audience. Or no, wait, that was the issue. That was the issue. He did have permission to display it to the courtroom audience, so it can be on the monitor. We just didn't have permission for it to be published, you know, to us at home, to be captured on the cameras. But the camera was already on it when it came up. I suppose the way to handle it would have been for Mr. McBride to either bring it up on the witnesses thing first, you know, because he wanted to do the comparison. Don't put it up in the courtroom at all. One option, but certainly. But even if he wants to put it on the courtroom, just to make sure, you know, this is something the court has previously ruled is not to be published to the camera. So it's going to be coming up on the screen now. The foresight to do that would have been good. Seems like maybe it's a little bit of a lack of communication coordination between the prosecutor who's asking the questions and the intern who's going to get thrown under the bus, you know, who's running the computer, the exhibits, doing that part of it. We got the short end of that one for sure. Bass player 2011 IFY. To put this in perspective, 1 in a trillion that it's Tyler's DNA that is there. That is 50 times more likely than winning the Powerball. It isn't really. Again, like, these statistics are so complicated, and that's one of the issues. That's one of the issues that's why there's so much argument about the language and stuff like that. It's not 1 in a trillion that Tyler's DNA is there. It's that if we assume it's either Tyler's DNA or a bunch of other people's DNA, we are assuming these are the explanations. If we assume these, then it's 1 trillion times more likely to be Tyler than the other. Does that distinction make sense? That's what the likelihood ratio is. It's not we're saying definitively it's his there. It's saying what is there is consistent with him. It's consistent with what it would look like if he had contributed. But there is uncertainty for a variety of reasons. The whole deconvoluting the mixture is one piece of it. And just sorting out why the electropherogram looks the way it does. Why do the peaks look the way they do? Things like that. But also just the uncertainty about the actual population level distribution of these alleles. These statistics, there's a reason why it's based on unknown, unrelated individuals. This is an abstract. Because in the real world, people are related. And that's why there's this problem, this lack of real certainty about it. It's really about rarity. We can identify. I might be going a little bridge too far here, but I'm going to say it anyway. Pretty sure I'm right. Statisticians in the audience, please correct me. Pretty sure I'm right. What this likelihood ratio is expressing, in my understanding, is it's giving you a measure of uniqueness. Now, they just kind of cited this thing from their standard that says it doesn't, the NIST thing, so that's why I'm like, okay, but this is just my understanding, so bear that in mind. It's uniqueness. The higher the number, the more unique this combination of alleles is. But uniqueness is not the same thing as rarity. The fact that it's unique doesn't mean that it's rare. Okay, a genetic sequence that creates a person of a certain, a Caucasian person with blue eyes who has a, I don't know, a super rare medical condition, and is also obese, prone to obesity, prone to dementia, all of these, like, just different combinations of traits. The more combinations of traits you have, the more unique that's going to be. But it doesn't mean that that's rare. Doesn't mean that's the only possible person that could have this genetic combination, because that person could have a twin. That person could have triplets. Doesn't necessarily mean it's rare. And you're dealing with rarity when you're talking about population level statistics. So hopefully I didn't completely blow that to you statistics people, but that's kind of the way that I see it. So it's establishing uniqueness. There's still some uncertainty though about the significance of uniqueness. Hopefully that makes some sense. Willow's Angel, why couldn't the judge make a ruling today on whether or not this preliminary hearing is sufficient to go to trial? He could if he wanted to. He could if he wanted to. He could say, I have enough information. I don't need to hear more. You can do your argument. But he is not doing that. He's being very accommodating to the parties. And in part, I think this goes back to the comment he made a couple days ago to Mr. Novak. I'm not here to tell you how to present your case. I'm just the magistrate. I'm just here to process what you give me. And so if they want to, this is how they want to present the case. So he's generally going to allow them to do that. They want to put a whole bunch of stuff in writing, have argument on it. He's going to give them that benefit of the doubt, even though it's going to take us until, probably after a year. We'll be past the year anniversary probably before we know if there is a bind over. Patty6650, thank you for your coverage. I enjoyed your coverage of Karen Reed's trial. I'm sitting in Maine enjoying cherries from Washington. We enjoy truth. Oh, the Washington cherries. The Washington cherries. I have to tell you, the Washington cherries are kind of a canary in the coal mine for me, because we used to have cherry orchards everywhere. They used to be everywhere. Right just within like a mile of my house, there used to be thousands of acres of orchards, cherry orchards. And these are like large family operations for the most part. And even just since I've lived here, less than 10 years so far, every single one of them is gone. Every single one has been pulled out, and that old property is being subdivided, developed. There's literally like one little small family orchard left that's probably maybe an acre and a half of trees at the most. Thousands and thousands are gone. And that said, like there's been more. There's like more corporate cherries in Mattawa, Desert Air, and like these like areas that I remember from being a little kid. Literally nothing there. Dust, sagebrush, snakes, and now there's massive agricultural installations and stuff like that. So it's a big shift. It's for me, canary in the coal mine, big shift in the ag industry, period. That consolidation, the corporatization and stuff like that. Family farm has been dying for a long time. The estate tax doesn't help, but just really seems like a massive acceleration in recent years, and development, big contributor to that. So I'm glad we still have Washington cherries for you to enjoy, because they are fantastic. They're wonderful. They're so good. They're so good. I had cherry trees in my house when we first bought the house. There was an orchard here. I took the cherry trees out though, just because for purposes of pest management, cherries are some of the worst. Cherries are some of the worst to deal with. There's just not really a way to deal with them that isn't spray, that isn't organophosphate spray. And that's insect holocaust. I just prefer not to do my fruit that way. I like pollinators and stuff. I like butterflies. I like bugs. I'm a big fan of the beneficial. We plant things to try to attract them and stuff. So very, very hard to reconcile that with having the cherries. No, there's no IPM, integrated pest management. There's really no IPM for cherries because it's a fly. It's a cherry fly, is a cherry maggot. And so you can't, like a lot of the moths that are pests for fruit, they can do hormone disruption. They just interfere with the mating cycle. But that doesn't work for the flies. So really there's not a whole lot you can do, but blast them with organophosphates. And I don't want to do that in my orchard. So don't have my own homemade cherries, but I do miss the family farms. User XR numbers. If the judge gives the defense time to think about a remedy, he can't also expect them to follow the conversation about why the mistakes happened. It's unfair. I see what you're saying. I didn't catch if he was expecting them to have that conversation right then. I mean, he was saying, we want to deal with this now. not, you know, defer it to sometime down the road. I see what you're saying now. Did he not like pause and let them confer at the table? I think he did, right? Because then we paused. He's like, I want to watch it again anyway. The defense was saying, we want to think about it. The judge says, we're not going to kick this down the road. You know, this is important. I want to deal with it right now. But he also says, I want to review it. But maybe that was later on down the road. Yeah, Mr. Novak had wanted to break to discuss, and then the judge is like, well, let's hear from the state and the media. So I see what you're getting at. I do. I see that. That if the defense is kind of required to confer amongst themselves, they're not going to be able to divide their attention and also be paying attention to what the state and the media have to say. I get it. Thank you. Thank you. I think we are on the same page. And yes, I agree. I think it would generally be better to pause to let the defense discuss those things. And especially if he knew he was going to watch it again anyway, why not do that right when you know they want to have a conversation anyway? Then there's just no confusion. They aren't sure. So state's called to talk. Defense is trying to give the judge what he wants and decide on their remedy. Good point. Very good point. Greg Malden, 3825. The judge is fueling the crazies who profit off the conspiracies. Well, it's certainly not helping put it to rest. Not helping shut the door on the nonsense. The thing is I mean, that is also an impossible task. Recognize there are going to be crazies, no matter how transparent and thorough this process is. Because there's always going to be people that just will deny the evidence, will just say there's no evidence, you know, make assertions, flat assertions about reality that are not consistent with what you and I are observing reality to be. That's not going to change. So eliminating the crazies is not a viable forecast, but it's not helping, is it? Could be doing more to help, and this isn't achieving that. Potbelly, rifle wrapped in towel. Wouldn't DNA transfer from towel? Maybe. Maybe. This is stuff all gets very complicated. You know, what's the material? What's the material? The towel itself is absorbent, so if it's like sweat, might not expect it to transfer. It just absorbed into the towel and then dried and then it's there. Skin cells, maybe more likely. Like there's so many moving factors. It certainly could. You couldn't rule it out. You couldn't say impossible that that's how the DNA got there, but nor can you prove that that is how it got there. Nathan Danner, 4030. My sister was murdered in Issaquah, Washington. Very sorry to hear that. And after the WSP investigation search through the house, we still found a bullet inside her computer case. It went through the GPU and lodged under the PSU. So evidence that they failed to recover. This does happen. It doesn't put our law enforcement investigations in the best light, does it? It does happen. Just recently, been watching. Guys, we still have the sentencing to go. I realize I have kicked the Christy Martin can down the road for quite a while. Thought I was going to get to it a long time ago. Had a thing come up that made me change my my schedule around at kind of the last minute. So we still have the sentencing to get to with Christy Martin. But anyway, we've been watching this whole trial. Christy Martin, women's former super welterweight boxing champion of the world, her husband and trainer, Jim Martin, stabbed, shot, and attempted to murder her, and has been, at our point in the stage here, convicted of attempted second-degree murder. And we've been watching that trial, and a big feature of the defense was they recovered 2 shell casings, but only 1 bullet. And Jim was asserting a self-defense claim. He didn't testify, but that was the defense he was trying to go with. And he was trying to argue that Christie had threatened him first, basically. And so the absence of being able to explain where is this other bullet, and when did it get discharged, that created a potential window for this defense to develop. So it definitely does happen. Don't always cover themselves in glory, our investigators. I also have to say, I don't know how long ago this was. WSP has had a shortage for like at least a decade. At least, probably longer. At least a few hundred people, short of what they need for staffing. And we also, we have in Washington a real variety of experience and expertise and training and stuff like that when it comes to evidence collection. We don't have a single centralized crime response team like it sounds like in Utah they have with this SBI. You have the local agency doing it, you have the troopers doing it, you have the county doing it, you have the feds coming in and doing it, and they all may have very different standards for how they do that. It's only kind of been recently, I want to say maybe the last decade or so, that the crime lab has, the state crime lab, Washington has a centralized state crime lab, has started to include evidence response as a service that they will offer, but it's limited geographic area. And the irony is that I've only ever seen it in Spokane. It's like one of the, more resourced areas in all of Eastern Washington, like the last place you would think you need specialized evidence assistance. You need it more in maybe like Pend Oreille County, maybe more over there in Waterville, just kind of putting this out there. And so, yeah, sometimes you get local agencies that really don't know a whole lot about how to preserve a crime scene, and they're just kind of muddling through. So lack of, standardization, consistency, stuff like that, that doesn't help either. But I'm very sorry you had that experience, because that's shitty. And that's going to be real disappointing and real disillusioning, I'm sure. Can't imagine you felt like you were being well served by your investigators. Ruben Rios, 3429. Why do you think the parents were not used during this hearing like Lance Luna was? They didn't get the 1102s from the parents. I think there's possibly a couple of reasons why. It wasn't strictly necessary. Would it have been helpful? Absolutely. Sure. It's more incriminating statements, but it wasn't strictly necessary because we already have incriminating statements, and so it's kind of marginally helpful. Meaning like on the margin, you're adding to something you already have. So yes, it's helpful, but like marginally. But the trade-off is if you do have them as witnesses, number one, the potential risk of exclusion from the courtroom. We heard they invoked the rule of witness witness exclusion, sequestration. If you're going to testify, you don't get to be here. So it means it can't be live testimony. It would have to be this recorded statement thing. But it's going to be very, very, very painful for these parents to do that. They're almost certainly going to have to do it at the trial. But if you don't need it, the compassionate thing to do is not make them go through it unnecessarily. I want to think that's the motivation behind it, that this is a kindness to them, that they didn't have to do it. And so they didn't. It could be strategic too, you know, if they, you know, it's going to be painful for them and they really don't want to, and you make them do it anyway, then maybe they will resent you, and then maybe they're harder to work with and they're less cooperative, and so on and so forth. And I guess it can be a little bit of both. But I think it's just mainly because it's going to be the worst thing they've ever done. Worst thing they've ever had to do. Get on the stand, testify against their own child. So you just don't make them do that more than they absolutely have to. And if you can avoid it because you really don't need it, it's not adding significantly to what we already have, then let's go ahead and not do that. Mark E, why take so much time until the closing? Because of the briefing schedule. They want to do it in writing. They want to submit arguments in writing, 35-page briefs each, plus an 18-page reply by the state. So the time to do that, state gets 2 weeks from Tuesday, because Tuesday is about when they anticipate the transcript would be ready. So state gets 2 weeks, then the defense gets 2 weeks to respond, and then the state gets a week to reply, and then the September 1st was the next date the court had available to be able to come in and argue it. Just a factor of the briefing schedule. Bass player 2011 IFY. That's what I meant, just bad wording on my part. Believe me, it happens to all of us. Bass player 2011 IFY. Oh, so it's scientists making it complex so they can keep their job. Now I really don't care. This is kind of my take on the AFD stuff. Generally, I don't take a lot of issue with the DNA, you know, and I don't take issue with the need for good forensic science anyway. It's in everybody's interest to have good, solid forensic science so that it's objective and it gets us right results. That's what we all want. Right? We have a better criminal justice system if we have better sources of information that aren't tainted by, you know, bias and incentives and things like that. Anything we can do to improve that is good. And generally speaking, DNA is a path in the right direction. It's got its flaws, but they're just significantly less than AFD, for example, forensic toolmark stuff, which is just, it's such a relic to me of a bygone era. It just, it doesn't exist anymore when expertise was a little bit more easily claimed and asserted. I've told the case many times, told about the case many times. We have a case in Washington from the 1980s. Because one of my hot button topics is pseudoscience in the courts and how easy it is to get bullshit in as evidence by calling it science, convincing somebody it's scientific. And the courts don't draw the line. They just don't. If the prosecutor wants to put it in, very hard to get the court to say, nah, that's bullshit, actually. So the case from the Washington Supreme Court where we got the line drawn, it was actually a bridge too far, was the cop testifying about his dog who's able to detect a fresh guilt scent. And so the dog in this particular case tracked the fresh guilt sent to the defendant. And they're allowed to testify. A trial judge lets this in court. Lets this in at trial, and a guy gets convicted on this shit. And this is where the line is drawn. All right. No fresh guilt sent. Even that's going to be a bridge too far. But you realize, you see how extreme that is? How much still bullshit, but not that bullshitty, still makes it into court. This is all what the firearm, the tool mark and firearm analysis is to me. It's hearkening back to that era of the fresh guilt sent, because it's that level of voodoo. But the thing is, they've known about it for decades now. These criticisms are not new. You've had all the time in the world to figure out how to fix this. And they don't. And they're hostile to the mere idea that they should, that there's any problem. And they, many of these examiners continue to come into court and gaslight people about what it's capable of doing. And that's where I see it, yeah, they could do foundational studies. You could get a huge library of firearms and ammunition and get tons of samples and do all kinds of data collection and stuff like that, and be able to actually process and get some statistical foundation for some of this stuff. But they aren't doing that. Why aren't they doing that? Why aren't they doing that? Well, I have to think, being a little cynical Gen X, a little black-pilled on this legal system, that it's because it's a non-zero risk that trying to validate it would show that they can't. It would show that you can't. That there's just too much variability, too much, too many complications to be able to make it a clean system. Too much chaos. I mean, it's not chaos, but it's just too much, we talked about yesterday, like just the completeness of the ignition of the powder, the, exact condition of the bullet, how, tiny little bit of play within the chamber and within the barrel while it's being fired. Like, all of these things just introduce tiny little minute differences. And being able to calculate for all of that is going to be, it's going to be a task. And so possibly that if you try to do it, it would just show that it's not possible for you to. And now what's happened to your golden goose of your tool mark examiner training and certification and yeah, now you're like definitively bullshit. This is my feeling. This is my feeling about the firearm stuff, the tool mark stuff. The DNA is complicated. Unfortunately, there's just no real way around that. The DNA is complicated. The hard thing really is simplifying it so that it isn't misleading. Because that's the risk, is being misleading. We need that epistemic humility. Key to science, key to good science, the epistemic humility, the limits of what you know, honor them. And it's just hard to do with these very complex topics. Lisa Dotson, 613. Could Lance and Tyler get married so that Lance wouldn't have to testify against Tyler in court? I'm not sure if they could while Tyler is in prison. So typically being incarcerated does not deprive you of the fundamental association right you have under the First Amendment to get married. You have a right to get married even if you're in prison. And so there are typically ways to be able to achieve that. Whether you'd be able to pull this off is maybe a little bit more in question, because we are talking about communications that precede the marriage. Usually there's two elements to spousal marital privilege. Not all states recognize both aspects of it. Not sure about Utah. I would have to look. You have the rule that spouses can't be compelled to testify against their own spouse. So that's one aspect of it, the spousal testimonial privilege. But then there is also that the other option is the spouse can't be compelled to reveal communications, marital communications that took place within the marriage. That's the marital communications privilege. So they're two separate but very related things. Not every state recognizes both of them. The marital testimonial privilege is, even in states that recognize it, it's typically got exceptions to it. Would have to think a lot about, you know, whether and how any of this would apply. But for example, if that was always the rule, you can't compel a spouse to testify against the other spouse, then every single person accused of domestic violence is going to be able to keep their spouse from testifying. If you're married in an abusive relationship, you would just be able to keep your spouse from ever putting you in prison, because you'd just be like, I assert my privilege, and they can't testify. So there are exceptions to that one. The marital communications privilege is only going to apply to communications that occur during the marriage. So the fact that this preceded the marriage, probably going to be a problem for that. So those are the rules. Don't know exactly how they would play out in Utah, but I'd be surprised if this was like, you know, prosecutors hate this one trick. Don't think it's generally that easy. Plus, if Lance is thinking that, you know, Tyler's gonna throw him under the bus anyway, why do you want to marry the guy? Tyler, you know, Lance would have to want to marry the guy anyway. So just part of the things we have to consider. Oh, I see there's a new filing about from Erica Kirk wanting the probable cause ruling earlier than before September the 1st. Asking it to be done no later than September the 1st. It's interesting. The judge kind of already knows she's invoked speedy, so I don't think this is going to change, but he is documenting it, making his record. So, goes to the reasonableness of the delay and the need for additional time. Yeah, we'll see what happens. I guess that might make it a little bit more likely that Judge Graff will go ahead and rule from the bench on September the 1st. And, you know, again, it's not like he can't. He's going to have all the evidence. He's going to have all the briefing. He has what he needs to be able to do it. It's just, I guess, a slightly bad look to hear arguments and then, you know, issue the ruling you were going to issue anyway, because it just kind of makes it transparent that the arguments didn't matter. But, you know, take some time, hear the arguments, take half an hour back in your chambers, drink a cup of coffee, tweak your opinion slightly if you need to. That could be addressed. I mean, I don't think this seems like a crazy ask, but we'll see what the judge does. Seems to have been gotten a little, I don't know if harsher is the right word with Mr. Nyman, but just maybe less tolerant of his participation, more inclined to shut it down, more inclined to I said what I said. Interesting how this is developing and fleshing out. That'll be interesting, interesting to see for sure. All right, guys. Short day. Got some time to get our naps, get our sleep recovery, get outside, get that sunshine on the retinas, get the little UV on the skin, just a little, not crazy, but enough to just give us that little vitamin D boost, get the blood flowing, get the endorphins from some movement. It's that time, I think. We spent a lot of time in our chairs watching the live stream this week, so got to make sure to take care of our little biological systems here, have needs too. So let's take some time to do that now, shall we? I will. If you don't want to do it, it's fine. I'll do a little extra for you. But get ourselves in tip-top shape to come back at 7:30 tonight so that we can do our recap. Not just today, but also let's look at the week as a whole. Let's look at the week as a whole. Let's take a look at these charges and what the court's going to have to find, what the necessary evidence is going to be, and help us kind of forecast where there might be room to maneuver, what we might expect to see in this briefing from the different parties. Shelly J, side note, I have loved watching your kitty journey on Twitter. As someone that fosters kittens, I love that you kept them, all 4 of them together, all 5 of them. But thank you. Thank you for covering. It's my pleasure. Yeah, going from 0 cats to 5 cats has been quite an adventure for me as well. So I'm glad you're enjoying it. I have to say, cat ownership, it's a different world now. Oh my Lord, the litter robot, game changer, the vacuum de-shedding tool, game changer. That was what I was talking about yesterday when Joni was in here, and there was just like explosions of cat hair, and suddenly there's cat hair all over my mic and stuff like that. And Joni, she needs vacuumed. That's what that was about. It's just, yeah, it's so much easier to have a cat now than it used to be, and certainly way easier to have 5 cats with litter robots. So I'm glad you've enjoyed it. I am absolutely enjoying every minute of the cat journey. Guys, let's call it a morning. Let's call it a morning. We are done. We are closing the curtain on the evidence for the preliminary hearing. We have learned everything that there is to learn. Now it's just the putting it together. So we'll be back at 7:30 to start doing that. Enjoy the rest of your afternoons, guys, and I will see you then.